guys, welcome back to my channel. So this is Ifeoluwa Olubi, your woman of many parts. Alright, today we want to talk about something that is trending. On Wednesday, Meta launched Threads. Last night I just saw everybody seeing Threads. We are trending, we are needling, and I was wondering what is happening. Wednesday, Meta launched Threads, a social media platform, right? Very similar to Twitter. And within a short period of time, I think between Wednesday and Thursday, they already had 30 million subscribers. Of course, you have to have an Instagram account. You log in through your Instagram accounts and you start trading. So I woke up today with a lot of people asking me and saying, wow, is Twitter, as Meta infringed on Twitter's patent or copyright or intellectual property right? So today I am not discussing whether Threads is going to beat Twitter, in terms of popularity with people. I am coming from an intellectual property perspective. And of course, I am your favorite IP teacher and IP lawyer. All right, so let's get into it. Threads look similar to most people to Twitter, and in fact, Twitter's attorney has written Meta, stating that it is infringing on its trade secrets, confidential information, and other intellectual property rights. So let's look at it. Is Threads really infringing? Well, as we keep watching the legal battle, we only have the information, the little information that is available in the public for us to, have this discussion. So let's look at trade secrets. What would you call a trade secret? A trade secret refers to confidential information or any secret information a business enterprise has that has commercial value. So the important thing is that it must be secret information, it must have a commercial value, and you must have taken reasonable steps to keep that information secret. So Twitter is alleging that Meta probably used some of its, tech people that is laid off. Of course, we know that in the tech industry recently there's been a lot of layoffs, both on the side of Meta, Twitter, quite almost all the social media giants, really. So Twitter is alleging that Meta probably used one of its, engineers that has been laid off, or some former employee, to develop this particular app. Although Facebook replies and says no, they don't have any of the engineers and it's not based on their own confidential information. But let's get back to the discussion about trade secrets. So, having said that, a very popular example of trade secrets in the world is the Coca-Cola formula, Coca-Cola drink. So it's believed that that information is kept very, very secret, top secret in the company, and that is one of its secrets of its success. So if your competitor gets that information, especially through unscrupulous means, right, or through one of your former employees that broke an NDA, a non-disclosure agreement, of course you'll be liable for infringement. But one thing we need to know is that when it comes to trade secrets, reverse engineering is possible. So that means that you can look at somebody's, in this case, an app, think for yourself, how did this person arrive at this product or this app? Let me try and get it on my own. And if they got it on their own without using your own secret information, that is permissible. So could it be possible that Meta reverse engineered Twitter? We really do not know. And there's also the aspect of copyrights, right? So in intellectual property rights, copyright averagely is used to protect software. It's used to protect apps, computer programs and software. So in this case, Thread or Twitter will be protected by copyright. But when it comes to copyright does not protect ideas. So the idea and the concept of Twitter cannot be protected by copyright. It actually protects the expression of ideas. Let me give you an example. We've read so many love stories, we've watched so many romance movies. We all know they have similar plots, right? But every single person that has produced a movie or written such novels, they have copyright in how they have expressed that plot of a boy meets girl and how they have a romantic ever after, right? So Twitter cannot say no other person should develop an app close or similar to it as long as they have not copied their source code. So what copyright will be protecting basically is the source code of Twitter. So if somebody else has a different source code and comes up with something like what you do, you cannot stop them from, you cannot allege that they have infringed on your copyright. So say much as long as Threads has also not copied Twitter's source codes. They have chosen to express the idea of a Twitter kind of platform in their own way. They probably may not be held to be infringing when it comes to copyright. How about patents? Patents, protect a new invention, right? So you see that Twitter is not even so far from the information available. Twitter is not going down the patent line because if anybody has a patent around something like this, it is Meta. Meta has a 2012 patent about communicating in news feed. So Twitter is not even alleging patents. But yes, it doesn't mean we cannot have software patents. Software patents are possible, though many jurisdictions do not give patent protection, or some jurisdictions do not give patent protection to software. But if the software is embedded in a machine, has industrial application, you can prove, it drives a particular technology, or, a particular machine, you could get software patents for it in some jurisdictions, not in all jurisdictions. So I think that at the end of the day, it is a question of facts and the circumstances of the case. If this ends up going to court, for the court to say, okay, Meta has infringed on Twitter's intellectual property rights, in this case, maybe trade secrets or maybe copyright. And another thing we need to bear in mind that most jurisdictions have competition laws, laws that will allow free play, or antitrust laws that will allow free play in the world of competition in business, right? So there's no most jurisdiction will also not allow Twitter to have a monopoly on something similar to whatever kind of platform, like a public space that they have. So let's see. Elon Musk has alleged that competition is allowed, cheating is not allowed. Has there really been cheating? Has there really been an intellectual property rights infringement? We are yet to know because it's a really new development. Today is Friday, it was released on Wednesday, so this is just the third day. As the legal battle unfolds, will come to understand better and better what is really happening. But so far, with the little information we have, I think it's a really, really slippery slope. If Trade is able to prove that there was reverse engineering, despite the fact that it looks similar, maybe there's nothing much. If there is no evidence that they actually unscrupulously, or fraudulently gained access to Twitter's trade secrets. Also, copyright. What if they just developed their own source code? They have not used Twitter's source code to develop their own app. So let's see how it goes. But whatever the case may be, I hope that you are trading. I hope you are trading. Keep trading. And please kindly do not forget to subscribe to this channel. Please follow me also on Threads. I'm there, so I'm here to see what is happening, to see how this goes. If it's going to be really popular with people or not, you really want to be in there before it's too late to come to the party. Don't forget, please subscribe to this channel, like, share, and comment. I look forward to hearing from you, especially my IP family. What do you think? Do you think there's been an infringement? Do you think that this is going somewhere, or you think that at the end of the day, we are not going to hear much about an IP infringement? It's too early to judge, to stay on either side, but I just thought to enlighten you about what this means, whether until the court decides, right? It's still a matter of public opinion. Thank you so much. To see you some other time. Keep trading. Bye.